Hello, I'm Michael Ettinger from Ettinger Law Firm. I'd like to welcome you to our webinar, 4 Advantages of Using Trusts. In the photo, you'll see I'm up at the top. To my left is my lovely wife and law partner, Suzanne Ettinger, a number of our other attorneys and staff. We have hundreds of pages on elder law estate planning topics at our website, trustlaw.com. And our practice is limited to trusts and estates, wills and probate, estate tax saving strategies, Medicaid applications, and Medicaid trusts. We have 14 offices located throughout New York State in the counties listed below. I mentioned that we're an elder law estate planning firm. So what is elder law estate planning? Well, it breaks down into elder law, which you hear a lot about, but you're not quite sure what it is. To our mind, it's disability planning. And disability planning has risen to the forefront because we're all living much longer than we used to. Do you know we live an average of 32 years longer than we did just a century ago as a result of advances in medical science, better nutrition? But it turns out, with everybody living so much longer, more and more people become disabled. In fact, they say the chance of any of us becoming disabled is about 50%, half of all people. Fortunately, later in life, when I say disabled, I mean unable to handle our legal and financial affairs. With so many people becoming disabled, the law has addressed the issue of who's going to handle their affairs for them. And for that, we have power of attorney, somebody to handle your legal and financial affairs. We have health proxy living will, somebody to make a medical decision, including end of life, pull the plug, so to speak. We use trust for disabled persons. We have guardianship proceedings for disabled persons, and a very big part of elder law, all the rules and regulations about Medicaid. If someone needs to go into a nursing facility or needs care at home, what assets are exempt? What are you allowed to transfer? And how do you plan 5 years at a time to protect your home and life savings? We're going to cover all this on the elder law side. And then estate planning is actually a nice way of saying death planning. In law, your estate consists of all of your assets, your investments, bank accounts, retirement accounts, any annuities you have, insurance policies, any real estate. Add it all up, and that's your estate for legal purposes. And estate planning has been defined as getting those assets on your death to whom you want, when you want, the way you want, with the least amount of taxes and legal fees possible. And it turns out everybody needs an estate plan because the mortality rate, unfortunately, is stuck at 100%. So elder law estate planning is an area of law which combines the features of elder law, disability planning, and estate planning, which is death planning. Here at Ettinger Law Firm, we're fond of saying we use trusts to create order out of chaos. And here's a preview of what we're going to be talking about today. Trusts avoid the pitfalls of wills by saving time and money in settling the estate, because trusts don't have to go to court as wills do for the probate proceeding. It avoids legal guardianship if you become disabled. We're going to talk about guardianship and why it's something you want to avoid. It keeps your assets in the bloodline instead of going to in-laws. Here we're going to be talking about the Inheritance Protection Trust. It protects your home and life savings from long-term care costs. And here we'll be talking about the famous Medicaid Asset Protection Trust. And if I had to sum up all of elder law estate planning in one word, that word would be control. What we're doing here is we're taking back control from the courts and government, giving it back to you and your family. So please try to keep that word in mind, control, because it's going to be a recurring theme throughout this presentation. Keeping control in your family and out of the court system. So let's look at the first of the 4 reasons why trusts protect you better than wills. And that's because trusts protect you from guardianship proceedings if you become disabled. Wills don't do that. So we already mentioned the chance of becoming disabled is about 50%, fortunately for most of us later in life. When I say disabled, I mean unable to handle your legal and financial affairs. Now, if you only have a will, the will, as you know, takes effect at death, so there's no plan for disability. Well, of course, people who have wills still become disabled, so what happens to them? Well, because they don't have a plan, New York State has written a plan for them. It's called guardianship proceedings. And these proceedings could be expensive. They can run in the tens of thousands of dollars. They're time-consuming, involving multiple court proceedings, and they're very stressful because you don't know how long it's going to take, how much it will cost, and most important, who the judge will appoint as the legal guardian. A lot of people think, well, my sons and daughters are capable, but some of the judges feel they have a conflict. What's the conflict? If they spend it on you, it's coming out of their inheritance. There may be sibling rivalry. Maybe more than one of them wants to become the legal guardian, and the judge finds that problematic. Or the judge may determine they don't have the knowledge or experience to be a legal guardian. It's up to the judge. So it can and often is a stranger. How do these guardianship proceedings start? Well, they can be started by a family member who finds that mom is acting strange or not handling her affairs properly. It could be dad, of course, or is being taken advantage of by another person. It could be started by a hospital, a nursing home that wants to guarantee payment. And it could be started by the Department of Social Services themselves. Once a legal guardian is appointed, you cannot take back your affairs unless you can prove to the judge you no longer need a legal guardian. To do that, you have to go back to court and have a trial and prove to the judge's satisfaction you're able to handle your affairs, so the judge cancels the order, puts you back in charge. Can you see yourself here in your late 80s or 90s in court, on trial, fighting to get your own assets back? And do you know who's opposing you sometimes? The legal guardian. Why is that? Well, as you might imagine, it's the end of the payday. Not a happy place to be. And finally, the legal guardian has limited options to protect your assets from long-term care costs. Once a legal guardian is appointed, they can only spend the money on the person they're guardian for. So you generally have the state's plan, spend it on you till there's nothing left. So needless to say, no one would want a stranger handling their affairs. So how do we avoid guardianship? Well, with a revocable living trust, you can avoid guardianship because unlike a will, the trust takes effect, which takes effect at death, the trust takes effect while you're living, which is why they call it a living trust or a revocable living trust, because you can do it at a revocable living trust because you can undo it or revoke it at any time. So let's say your name is Mary Jones. You appoint yourself the trustee or manager of your trust, and now you have to retitle your assets into the trust. So let's say I have a deed somewhere here in the state of New York. We'll prepare a new deed and deed the property from Mary Jones to Mary Jones, trustee of the Mary Jones Living Trust, dated whatever the date of the trust is. Then we'll show you how to change and name your investments, your bank accounts, everything except IRAs. We'll talk about those a little later, but generally, all of your assets get retitled. Now everything says Mary Trustee, the Mary Trust. Then what happens? Well, nothing happens. You buy and sell the same as before. You file the same income tax return as before. Everything's exactly the same as before, except, like tens of millions of people around the country, your assets say Mary Trustee, the Mary Trust. Nothing actually happens until Mary dies or if she becomes disabled. At the moment, we're talking about disability. So what happens if Mary becomes disabled? In the trust, she wrote in, I'm in charge now, but if I become disabled, I name so-and-so in charge. Who do you think she picks? Who would you pick? One or more of the adult children. So in this case, we'll say she picks her son, Bobby. So she's named Bobby the backup trustee if she becomes disabled. What does Bobby have to do to take over the trust? He has to get a letter from her treating physician saying, Mom is unable to handle her legal and financial affairs. With that letter alone, he's able to take up the trust, take up the trusteeship of the trust. So now the person you know and trust is in control instead of the legal guardian. Well, what a difference. What is this person going to do? He's going to come and see us here at Ettinger Law Firm, as people do many, many times a week, and say something to the effect of, my mom set up her trust with you 25 years ago. Now mom needs to go into a nursing facility. Can you help us save and protect some of the assets? We'll say, as a matter of fact, yes. Under the Medicaid law, we can always save at least half the assets, even on the nursing home doorstep, because you're in control and you have the right to move the assets. And under Medicaid, it's move it or lose it. So let's say with the home and everything, mom has $700,000 in assets. We can save at least $350,000 because the son is in charge and he's allowed to move the money, as opposed to the legal guardian who is not allowed to move the money but can only spend it on mom till there's nothing left. Now it's true, just for to be perfectly clear, a legal guardian can ask the judge for permission to protect mom's assets, but I've handled those cases, and sometimes the judge turns the legal guardian down, or sometimes the legal guardian doesn't make the application because it's not their money and they don't care that much about it. So this is a much safer way to go. But with the revocable living trust, you have a guarantee that you will get the people you choose in the event of disability instead of the court-appointed guardian. And that's a tremendous peace of mind for you, because any of us are only as good as our backup plan. So we like trusts, avoid guardianship, keep control in the family, and you have these asset protection options. Let's look at the second reason why trusts protect you better than wills, and that's because trusts protect you from probate court proceedings on death, wills don't. So one of the drawbacks of wills is you're handing over control, there's that word control, of your estate to the court. In fact, one clever lawyer said having a will is like starting a lawsuit against yourself, because your family going to court to get your assets, there's nobody on the other side. So the issue is this: the executor has no power to act until the will has been approved by a judge. And this can cause lengthy delays in getting access to money and other assets. So, yes, the will was witnessed, notarized, supervised by a lawyer, but still it has to be approved to be a valid will. And that involves going to a lawyer, having the lawyer prepare a petition to the court. In the petition, the lawyer has to allege and prove that at the time of signing that will, you're of sound mind, memory and understanding, you are not under any fraud or undue influence, a number of other proofs. We have to get that petition served on all the heirs and potential heirs, get proof of service back to the judge. Now we have to wait for the judge to rule. Well, how long will that take? We don't know. Sometimes 2 weeks, sometimes 2 months, sometimes 2 years. In the meantime, you don't have access to bank accounts to pay bills. You can't access a stock portfolio to stop a portfolio that's sliding, or we're in a down market. You can't buy and sell and trade stock. You can't list a house for sale, etc. So it can be very onerous on the family. You actually pay considerably for this privilege. You're going to see in a moment, settling a will is about 3 times as more expensive at our firm as it is to settle a trust, close it out at death. It's time consuming, as I say, months and often average, I would say 1 to 2 years. And it's very stressful because you're in a position where you don't know how long it's going to take, you don't know how much it's going to cost, and you don't know when it's going to end. Additionally, wills are public records. Anybody can go down and look up how much you had, who you left it to, and where they live. Realtors take advantage of this. Financial advisors take advantage of this. So one of the major benefits of a revocable living trust, it completely avoids probate court proceedings for your trust assets. Saves time. How much time? Well, we settle trusts now in months instead of what could be up to 2 years in many cases in the will. It saves legal fees. We get a fee up to 3% to probate a will. We get up to 1% to settle a trust. Let's make that real. If we get 3% to probate a will, let's take a $500,000 estate. What's 3% of $500,000? $15,000. The same family, same assets, it's in a trust. We get 1% to close the trust. 1% of $500,000 is $5,000. So why is it $15,000 to probate the will, but only $5,000 to settle the trust? Well, the $10,000 difference is the cost of going to court. It's a 5-figure item, and for a lot of people, it's a few $10,000 bills. So you save a lot of time, a lot of money, and you don't have the court filing fees up to $1,250. But essentially, it avoids court control of your estate. Now, this has real-world practical effects. Let me tell you a story about a client of mine a couple of years ago. His father died here in New York. The son also lived in New York, but the father had a house in Virginia. The son was named executor under the will. So the son went to Virginia, listed the house for sale, found a buyer, signed a contract of sale, and then sent us an email saying, could you probate the estate so we could go to the closing? I said, Brian, what did you do? You can't list a house for sale. You certainly can't sign a contract of sale until the judge has approved you as the executor. This is going to take 2 years. Meantime, the buyers were living out of suitcases in a motel. They thought they were moving to the house. So we had to pay all their expenses, undo the transaction. And now Brian said to me, well, if it's going to take 2 years, I'm going to have to rent the house. I said, well, I'm sorry, Brian, you can't rent it either because you can't sign a lease agreement. So now he has to carry a house empty in Virginia for 2 years, which is no picnic, of course. Whereas if his father had a trust, he could have sold that house 2 weeks after his father died. What would he need? Copy of the death certificate. Once he has a death certificate, it shows his father's not the trustee, and under the terms of the trust, it says he's the trustee. That's all he would have to do. So a great deal of difference in terms of control. You can handle it quickly, immediately, without the need for a court appointment. This is going to mean immediate access to bank accounts, immediate ability to list a house for sale. Not that you would want to do it right away, but it's nice to know you can do it when you want to, at your leisure, according to your circumstances. Because the trust is not filed in court, there's no public record. Nobody can go down and look up how much you had, who you left it to, who you left out. Only the people named in the trust can see it, and in this case, it's the only people whose business it is. So you have privacy, and before we leave the subject, I want to take a moment and talk about something called the multiple probate problem. Let's say I own a house here in New York and one of those pastel-colored condos in Florida. Do you know you have to probate the will in every state we own property? So there's a probate in New York and a probate in Florida. You pay twice, but we can't start Florida till we finish New York, so it also can take up to twice as long. Fortunately, we can deed your property from any state into the trust and avoid all these probates. So to conclude, we like trusts to avoid probate. You save time and money, you keep control in the family, and you have privacy. Reason number 3, trusts protect the inheritance you leave from children's divorces, lawsuits, and creditors, and keep your assets in the blood for your grandchildren. Wills don't. This is the famous Inheritance Protection Trust that solves a particular problem that most people are not aware of, and that is this. Most wills read as follows: to my children in equal shares per stirpes. Now, the per stirpes is Latin, but what it means is, heaven forbid, my son or daughter dies before me, I leave their share to their children. I'm sure this sounds familiar to you. If my son or daughter dies before me, heaven forbid, their share to their children. Did anybody listening today say, if my son or daughter dies before me, I leave their share to my son-in-law or daughter-in-law? Well, nobody says that. But watch what happens in the real world. In the real world, most children survive their parents. So let's say I have a son, I'm going to call him Bobby. And in your will, we leave Bobby $500,000. Parent dies, Bobby gets the $500,000. Now, unfortunately, 3 years after Bobby gets the inheritance, he dies. Where does it go? Well, it goes to his wife. It's his money. Your daughter-in-law, can she get remarried? Share your $500,000 with a complete stranger? Well, she probably will. As we said earlier, people live an average of 32 years longer than they did just a century ago. So this is not the way people plan who see an estate planning lawyer, or at least one of us here at Ettinger Law Firm, because naturally we have some better tools in the toolbox, and the better tool here is something called the Inheritance Protection Trust. So instead of leaving it to son Bobby, we leave it to the Bobby Trust. And we say, Bobby, we're leaving your assets in the Bobby Trust, and we're appointing you as the trustee. You're going to be in charge. And under the terms of the trust, you can do whatever you want with the money. You could buy, sell, trade, spend. You could spend the whole thing. So we're not ruling from the grave. Bobby can be the trustee of his trust, spend whatever he wants, not ruling from the grave. But it protects it if he gets divorced. There's a number of protections. But first, the divorce protection. Because it's in a trust, separate name, not a social security number, it's protected from divorce. What's a divorce rate in this country? About half? Spouse can't touch it. protected by that trust. It does something else. It says, Bobby, if you get sued, who gets sued today in this country? Everybody. Creditors can't touch it. Not his name, not his social security number, lawsuit proof. But the key is this. It affords protection from the assets going to in-laws and their families, because this trust says, Bobby, when you die, whatever you didn't spend is still in my trust. So I direct whatever you didn't spend goes to your children, in other words, my grandchildren. What if he doesn't have children? Well, first to the children, but if he doesn't have them, it goes to the brothers and sisters, the nieces and nephews, always passes by blood instead of by marriage, keeps your money and your family for generations to come. So instead of the will, but stops at death, this inheritance protection trust goes 30, 40, 50 years after you're gone, protects that inheritance from divorces, lawsuits, and creditors, then passed by blood instead of by marriage. So who doesn't want that? Reason number 4, trusts protect your home and life savings from long-term care costs. Wills don't. How many people over the years had a will, but at the time they died, all the assets went to the cost of care. They had nothing to leave to their families. This is why, over the years, the Medicaid Asset Protection Trust has become so popular, because it sets up roadblocks that Medicaid can't break through. And it leaves a legacy for your family. So what is it that the Medicaid Trust does? Well, you're going to learn in a moment, it's an irrevocable trust. So let's take a moment and explain the difference between revocable and irrevocable trusts. They're mostly the same. They both avoid probate at death. They both avoid guardianship proceedings if you become disabled. They both keep your assets in the bloodline. But revocable trusts offer no long-term care protection because you could take it out at any time. So if you need to go into a facility or you need care at home, they're going to say, well, you have that money in your trust and you could take it out. Well, if you can take it out, then take it out and pay for your care. If you could get it, then it goes towards your care. So in the irrevocable trust, you put it slightly out of your reach, so you can't get it, so Medicaid can't get it. And do that by setting up 3 roadblocks. First, it's an irrevocable trust. Now, don't be afraid of the word irrevocable. It sounds scary. I will admit that. But fortunately for all of us, in New York, you can revoke an irrevocable trust. Now, how's that? Let me explain. It's irrevocable because you, the people who set it up, can't revoke it yourself. So law says, so far as you're concerned, that's an irrevocable trust. You can't undo it. But New York has another rule on the books that says that if every person named in an irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. Or who are all the named parties? You and your children, right? So if everybody signs, you can undo it. But what if one of them won't sign? Not a problem. We have a workaround. First, we amend the trust, we take that person out, and then we get it signed by all the parties. So you can always undo the irrevocable trust, which means what? You're always in control. You're not giving up control, and you perhaps know by now, control is one of my favorite words. We want you to keep control. So you name somebody else as the trustee because the trustee is the manager and the trustee could take it out. So if you were the trustee, they'll say, well, you can get it, give it to us. Fortunately, you can pick one or more of your adult children. So in this case, we'll say you pick your son and daughter, and you could require them to act together, but we usually find it's better to say that either of them can act as long as they keep the other one informed. The third feature of this trust is you must limit yourself to the income only. And you'll hear them referred to as income-only trust, and it means what it says. You only get the income. So if you put in CDs, you only get the interest. If you put in stocks, you only get the dividends. Now, if you put in your house, it doesn't earn income. So you get the equivalent, life rights, exclusive right to live there, use and enjoy that property during your lifetime. What happens to these assets? They stay in the trust, and they go to your heirs free of the expense and delay of a probate. So who is setting up these trusts and why are they doing it? Middle-class people, generally 70, give or take a few years, have a lot of assets you're not going to spend like your home. For heaven's sakes, move to protect your home. What happens if you own a home and you need care? They put a lien on the home. Many times lien gets bigger than the value of the home, and everyday counties all over the great state of New York walk away with people's homes, whereas it's totally unnecessary. For more than 30 years, you're allowed to take your house, put it into that Medicaid trust. Anytime after 5 years you need care, they can't touch it. So The Medicaid trust doesn't affect your lifestyle because you still get all your income. We're only talking about putting assets in the trust. It doesn't affect your income. You still get your pension, your Social Security, your IRA distributions, your interest, your dividends. Most people are living on their income. They're not going to even notice the trust. It makes sense for assets you're not going to spend, like your home, and investments you're only taking the income from or reinvesting. So you'll learn in a moment that certain assets are exempt from Medicaid, which are all your retirement accounts, IRA, 401k, 403b. So I'm talking here about non-retirement assets. And let's say you have a nest egg that's not retirement assets, and we're going to say it's $500,000. Many people come into the office and say, well, we don't need that $500,000 to live on. It's extra money just in case. Some other clients say, well, we're not spending the $500,000. We're taking the interest or dividends. Well, fine, the trust gives you the interest or dividends. But you realize, if you have a nest egg that you don't need to live on, you're actually safe keeping it for the long-term care industry. What do you think happens? Later on, client gets to 87, 88, the average age of a nursing home entrant. Now they need to go into a facility, but they still have the $500,000. Over at the business office at that nursing home, they're jumping up and down because you're private pay. In any given facility, about 3/4 of those residents are on Medicaid. Is Medicaid paying that nursing home $15,000, $18,000, $20,000 a month? Of course not. Are you getting the same care as everybody else? Well, sure. They just hit a home run with your money, and it's totally unnecessary. For more than 30 years, you're allowed to take that $500,000, put it into Medicaid Asset Protection Trust, still there if you need it, but somebody else can't come and take it away from you. Well, you put in your home, but you reserve the right to have the use and enjoyment of it, so you have exclusive use and enjoyment of the home, keep all your exemptions, senior, veteran, star. Now, you already know I'm very big on keeping control with the client. So you don't give up control with the trust because you reserve the right to change the trustee at any time. Yes, they're in charge of the trust, but you're in charge of them. You can actually fire them. Just have to come see us at Ettinger Law Firm, and we'll do the paperwork to change the trustee. Hopefully we won't have to do that. But it's nice to know you have that power. You're in control. More about the trust. The trust can sell the house and buy a condo. What happens is the trust sells the house, the money's paid to the trust goes out and buys the condo in the name of the trust. You don't start the 5 years over again. It's still protected. You like to trade your stock portfolio? After you put in the trust, you can continue to make trades. We know there's a 5-year look back for facility care, and sometime in the future, it was supposed to be in the year 2022, but it's being put off to 2023 or 2024. But at some point, we're going to have a new 2.5-year look back for home care. So we do want to take advantage of the trust now, so that if we need home care later on, we wouldn't have to wait 2.5 years to get it. Now, I said you can't take out principal. Remember, it's an income-only trust. But what if you need some money from the trust? Let's say one day you decide you need $50,000 from that trust to take your whole family and your lawyer on a round-the-world cruise. Doesn't that sound like a great idea? Well, you can't take out the $50,000, but you can make a gift of any amount tax-free to your children. So you need $50,000, you make a gift, tax-free gift to one of your children. Now, can they give it back to you? Well, they can't give it back to you because when we apply for Medicaid, we have to show them all your investment accounts, all your bank accounts for the last 5 years. If they see $50,000 came in, they're going to say, where did that come from? And if it came from the trust, you're sunk. So they can't give it back to you. But tell me, if you give them $50,000, you think they could take that $50,000, go pay the travel agent for the trip? Well, it's their money. They can do whatever they want. So there is a way to get principal out. As I mentioned earlier, but worth repeating, IRAs, 401ks, other retirement accounts are exempt from Medicaid. They can't go into your IRA. They do get the required minimum distributions because that comes out as income, but that's not $15,000 or $20,000 a month. That might be $2,000 or $3,000 a month. That will go towards your cost of your care. Now, the 5-year rule is not an all or nothing rule. Let's say you put your home into Medicaid trust, and 4 years later, you have to go into a nursing home. What happens? You only have to pay for the 1 year that's left because you already have 4. So it always pays to get started. If you don't make the 5 years, you only have to pay for the time left. So don't be concerned if you're elderly or you have a health problem. We do this for people all the time because we want to get the clock running. We're going to get a credit for whatever time went by. So our conclusion is very similar to our introduction, where we said estate planning with trust creates order out of chaos. And let's look at how it does that. It avoids guardianship on disability, keeps control in the family, and gives you those asset protection options. Remember, we can always save at least half. It avoids probate on death. Again, keeping control in the family, saving time and money in settling the estate, and keeps your affairs private. It protects the inheritance you leave from children's divorces, lawsuits, and creditors, and then passes it by blood instead of by marriage. And finally, and protects your home and life savings by making you eligible for Medicaid for home care or nursing home care if and when you need it. Now a word about our law firm's unique planning process. It's already begun with this seminar. This one's a webinar, of course, but same thing. We offer a free initial consultation where we're going to review your existing plan, bring in your will, trust, power of attorney. We're going to tell you if it's legally adequate. Usually it's not because it hasn't been done by an elder law estate planning firm, especially the power of attorney. The will is often out of date. But also, is it personally up to date? Are these the people you still want to leave it to? Are these still the people you want to have in charge? You get a free copy of our book, Elder Law Estate Planning, which I personally wrote, and we'll advise you which chapters apply to you. And your situation might be an hour or so worth of reading, and it's in plain English, so you should find it understandable. Right at the first meeting, we tell you, because we have a fee schedule based on what we determine your needs are, how much your fees will be if you decide to go forward later on. And then we ask you to come in for a second free follow-up consultation 2 to 3 weeks later to have your questions answered. So come in for the second free consultation. As I said, we answer any questions you have about what you read and what we discussed in the initial consultation. We draft the estate plan together with you, which means we ask you, who do you want in charge for legal decision-making, financial decision-making? Who do you want to make medical decisions for you? Who's your second choice for each of these? How do you want the estate distributed? All at once or over time? Equal shares or unequal shares? Any special situations that have to be addressed? And once we've completed the drafting process, we give you a detailed 3-page written proposal for the fees quoted. Remember, we mentioned them in the first meeting, but now it's in writing. And then we would say, what would you like to do? Well, fortunately, many people have gone ahead over the years. Here's where we break with tradition. Ettinger Law Firm does not use the retainer agreement. The retainer agreement is something signed by the client where the client retains the lawyer to go ahead and usually gives them a fee for 1/2 of the amount due at the beginning, and the other half is at the end. When we analyzed that a number of years ago, we determined that the retainer agreement is actually for the benefit of the attorney. But when we looked at it from the client's point of view, we saw that it's not really good for the client because the client actually has nothing when they sign the retainer agreement except for a promise. Now, fortunately, it usually works out, but not always. Sometimes the lawyer is too slow. Sometimes the lawyer makes mistakes. Sometimes a personality conflict comes up, but you've already paid. So what we determined was, instead, we have a fee proposal. You don't sign it, we sign it. Our proposal says, based on your say-so, we're going to go ahead and prepare all the documents. You'll come in 2 or 3 weeks later. After we review everything and you're satisfied and everything is signed, you pay at the end. But until then, you have no obligation to the firm. Because what we determined was that this puts you, the client, in control, which you already know how I feel about control. So now you're in control. Well, our theory is this. If you're in control, clearly it's the best place for you to be. Now, if we're here to serve you, and it's the best place for you to be, we feel it must be the best place for us to be. And it's worked very well. Over the years, we have over 30,000 satisfied clients. So you come in for that final meeting, review and sign the documents, and then you pay at the end either by check or credit card. You could pay all at once, or you could pay it in 3 installments. And now a word about our law firm's trademark process for after you sign your documents. Most people never hear from the lawyer prepare their estate plan. In fact, I would venture to say very, very few ever hear. And that's because most estate planning done today is still transactional. You get the document, thank you very much, goodbye. Well, we don't say goodbye at Ettinger Law Firm. We basically say hello, welcome to the firm. And we trademarked a process in 1999 called the Ettinger Elder Law Estate Planning Process to make sure if you have an Ettinger plan, it'll work when you need it, not when you wrote it, I hope, decades earlier. So we keep you up to date of law changes and other matters with our weekly award-winning Ettinger Elder Alert. We call it the Alert because it comes by email. But the key is this: every 3 years you get a letter from Ettinger Law Firm. Time to come in for your free review. Why do we want to see every 3 years? We have no other way of knowing. Did your health change, your assets, your family, births, deaths, marriage, divorces? So being that we've been doing it for more than 2 decades, we can tell you how it works. People come in after 3 years. Not too many people need a change, but we renew the acquaintance and we're building on the relationship. It's valuable. After 6 years, naturally, more people need a change. But statistically, it's been shown that very few people will get past 9 or 12 years without needing a major change. Who's in charge? Who they're leaving to? Something else happened. So now we do an amendment. Well, the amendment is legal work. You know, you'll have to pay for that, but we're still talking hundreds, not thousands, and you're good to go. The point is, when you go to use an Ettinger plan, it's designed to work when you need it, not when you wrote it decades earlier. And we have saved thousands of people, countless thousands of problems with this process. So I recommend it highly to you. Now, once you become a client of the firm, we don't charge for phone calls, emails, or questions. You already paid the fee, and if you have a question, you can call us or email us and get the right answer. And you know how valuable it is to be able to get the right answer these days. And as I say, by using this program, your plan is never more than 3 years old, works when you need it, not when you signed it. Now I'd like to invite you to schedule your free consultation with Ettinger Law Firm. A lot of firms charge for the consultation. That's why we indicate $500 value. It's still worth that, but we don't charge it, so you still stay in control. So to schedule your free consultation with one of our 11 experienced elder law estate planning attorneys, it can be in office, by video, Zoom, or by phone. Please click below to schedule a free consultation, and we look forward to seeing you in the office sometime in the near future. Thank you for listening, and have a good day.